Good morning. This is the Accessibility and Disability Policy webinar series. Today's session, Hot Topics in Special Education Law, is the topic, and I'm turning it over to Dorene Philpot, our presenter.
Hello there, everyone. My name is Dorene, and I'm a private practice attorney here in Texas. I represent parents and kids who have disabilities in regard to educational services in the public schools. And that's my sole area of practice. There's a huge need and not very many of us out there doing this work. So I get to do this work on a full-time basis. And I wish I had a clone because there's so much need out there. So let's go ahead and go to the next slide. So navigating some of these hot button topics in Texas special education law can be confusing for a lot of people. There's a lot of information out there. We will cover some developments from the legislative session and some challenges surrounding how Texas has identified and is currently identifying students who need special education. This process is referred to as child find. Based on some U.S. Department of Education directives, Texas is working to better identify kids needing such services. And so child find under the IDEA, which is the Individuals with Disabilities Education Improvement Act, refers to the legal requirement that schools have to comprehensively evaluate and identify all children suspected of having a disability that adversely affects or impacts their education. And go ahead to the next slide. So sometimes it's the parent of the child who points out that there might be a suspicion that this child has a disability that requires some additional or different educational services or at least an evaluation. And sometimes it's a concerned school district employee, such as a teacher. So the standard for triggering an evaluation is suspicion. It's a pretty low standard. It's not proof that there's a disability. It's the suspicion that this might be a student who does have a disability. And so what is educational performance? Sometimes people think about that as, you know, the usual reading, writing, and arithmetic, okay? But it actually can be other things as well. It can be things such as speech difficulties, social skills problems, behavioral issues, psychological problems, attention problems, study skill problems, organizational skills. Those sorts of things also can fall under the category of educational performance. So what happens? The parent signs a school district consent form for what's called a full individualized evaluation, also known as an FIE. We have a lot of acronyms in special ed law. And then that starts the evaluation process to confirm the presence or absence of one or more disabilities. And so how it's supposed to work, which is different from how it typically works, is there's a meeting to plan for what areas the parent and the school district think might need to be evaluated. So there's some planning and some thinking about what is it that we think we're looking for and how are we going to go about doing that. And so the consent for evaluation is based on this plan and this discussion, at least it's supposed to be. Then the initial evaluation, known as the FIE, is done. So how it actually works in many instances is frequently there won't be such an evaluation planning meeting. And so the result of that is that the parent and school didn't put their heads together to come up with the areas of suspicion, and it really is only the district's areas of concern that are considered in the evaluation process. So sometimes this means the evaluation is not comprehensive because it's not taking the parent's concerns into account. Okay, so once in a while, we see that some school districts may not promptly offer an initial evaluation consent form to the parent, as in physically give it to the parent so that the parent can sign it. And one would wonder, why is it that would be delayed? So, as a practical matter, if the school does not have enough evaluation personnel to conduct the evaluations that need to be done, or they don't have enough specialized services providers such as speech therapists, occupational therapists, psychologists, etc., there can be an incentive to evaluate and identify fewer students. Saves money, saves time, and less hassle. So that is one of the reasons that sometimes the consent forms are not given out quite as promptly as they might otherwise have been. So you've heard the saying that everything's bigger in Texas, right? Well, the feds, as in the U.S. Department of Education and others, say that we have a Texas-sized child find problem here. So the Texas Education Agency, this is the state agency that is charged with ensuring that all of the local school districts engage in competent child find activities, is in some hot water with the U.S. Department of Education currently. The U.S. Department of Education found, among other things, that some school districts were actually taking steps to keep the percentage of children who were receiving special ed and related services at or below an 8.5% cap. Now keep this number in mind as we go through this discussion. So how this all came out into the public purview was the Houston Chronicle came out with an investigative stories, a set of stories in a series about TEA's role in this problem. The Houston Chronicle reporter, who was the main reporter on the project, ended up winning a Pulitzer Prize. Now there's a boost for your resume, and he now works for the New York Times. TEA got some sanctions and a fine from the feds as a result of this information that came into the public view. Then TEA, Texas Education Agency, said it would stop imposing the cap or encouraging school districts to keep the number of identified students at 8.5. So, at the time that this was going on, due to this cap in Texas, only 8.7% of students were identified as eligible for special ed and related services during the school year 2015-16. And so these figures come from the TEA's own website. They're not numbers that I just pulled out of the air. You can actually look up those numbers, and also you can look up your own school district stats too. You can look at campuses, districts, you can look at different school years. It's not just the current data that's available at this website. So it's interesting and instructive to look at some of the school district numbers there. And you can also do, a statewide look if you like. So even after the Houston Chronicle series, and even after the USDOA sanctions, by the 2018-19 school year, even several years later, TEA's own statistics still show only 9.79% of Texas students have been identified. So we still have some work to do here. And to give you some perspective on how low this is, the best approximation of kids with disabilities may be 15.4% of the population. That is frequently the number that's been identified in other states. So where I came up with this number was that's how many U.S. kids from ages 2 to 8 that doctors have diagnosed with a mental, behavioral, or developmental disorder. And this is according to a March 2016 study by the Federal Centers for Disease Control and Prevention. And furthermore, the incidence of dyslexia, which is a reading difficulty in the general population, is understood and believed to be between 5 and 17% of the general population. And as you all probably know, being a competent reader affects all a student's academic areas. So when it comes to an evaluation consent, when it's signed, in Texas, there's a 45-day timeline for initial evaluation. So the very first evaluation that we're going to do of a student suspected of needing special ed and related services, there's going to be a 45-day timeline. If it's a re-evaluation, meaning the student has already been previously evaluated and we're going to evaluate the student again, then there's a 60-day timeline. So here in Texas, the initial evaluations are seen, it appears, as more urgent or more timely than students who are getting re-evaluations. So once the evaluation data is in, all the suspected areas of disability have been evaluated by the various evaluation teams, various members of the team, then decisions can be made about what the child's area of eligibility should be. And here are some examples of areas of eligibility under the IDEA that students are put under. It helps to have some sort of identification of the difficulty so that people can be targeting what the areas of need are. So these include autism spectrum disorder, learning disability. This can be things like dysgraphia, it can be like dyslexia, various other things. Intellectual disability, this is a term that's used instead of mental retardation. That term is not used anymore. It's been replaced. There's traumatic brain injury, visual impairment, and that's not necessarily something such as needing glasses. Emotional disturbance, this is a student who has some kind of a mental health impairment, typically. It could be something like bipolar disorder, schizophrenia, various other things, where the student does not exhibit normal or typical emotional reactions to things that go on. Other health impairment, this is something that is typically a health or medical condition. It can be something such as ADHD, something like that. Speech impairment, almost always there is a speech impairment that goes with autism spectrum disorder because autism is a communication problem. It comes with communication problems. Multiple disabilities, orthopedic impairment, and or a hearing impairment. So those are some of the examples of areas that the school district might identify that the student needs special ed and related services. Okay, so once we know what the problem is, then we can write an IEP. This is an individualized education plan or program for a student to address these areas of need and attempt to remediate the problems and help the student continue to make progress in the school program with the assistance of this plan that we're going to write. Okay, so goals and objectives. These really are the centerpiece of a child's IEP or education plan. Goals and objectives should be written in every area of deficit and every area of need. So if the student has, for instance, social skills problems, there should be social skills, goals, and objectives. So it's like, what are we trying to attain and how are we going to get there? Sometimes people don't realize that goals and objectives should be written in all areas of need, not just the academics. So remember, it's all identified areas of deficit and need. Then the team The ARD committee comes up with things such as related services, and those are things such as occupational therapy, travel training, parent training, in-home training. There's a whole laundry list of related services available to students. If they need it, then the school district is supposed to be supplying it. And then there's also accommodations and modifications. So these are things that are used to help keep the child in the least restrictive environment, if possible, or changes to the programming to assist the student in continuing to make progress. So let's say, for example, a student is incapable of taking notes in a classroom setting, but the notes are essential for the student to be able to make meaningful progress. So something that might happen is the student might be given access to notes taken by a peer, a classroom peer who has demonstrated, pretty good ability to take classroom notes. And so maybe those notes get shared with a student who is incapable of taking those notes. And so that really helps the student stay in the regular ed classroom where otherwise he might have to go to a more restrictive setting. So it's basically to help level the playing field and give the student things that he needs to help make the school experience more meaningful. Behavior plans. Behavioral intervention plans are something that can be included in a child's IEP if a student has behaviors that interfere with his learning or the learning of others. And it's not necessarily misbehaviors that we're talking about, Johnny threw a brick through the window. We're talking more about a lot of times things that are work avoidance. Every time Johnny goes to math class, he acts out. We come to find out, well, it's because math is particularly stressful because he doesn't understand it. And so, he's trying to get out of math class. So it can be things like forgetting or failing to bring materials that are needed to class. It can be, attention issues. It can just be a whole bunch of things, but it's not just misbehavior. So if there are behaviors that are interfering with the child's learning or peers, then we need to attend to those things in the IEP. Placement. Placement is decided based on, what is going to be the appropriate placement for the student. So for some students, that is a general education classroom with some supports and services. For other students, the least restrictive environment might be a residential treatment center. So it's really supposed to be individualized to the student's needs, what is appropriate for that particular student, not necessarily what we have is what you get. So it's what the student needs. And so the team decides the placement after devising the rest of the IEP. Okay, and I love this t-shirt. You see it on Facebook. Sometimes you can actually order this thing. So an IEP, an individualized education plan, can contain any provision or service that the ARD committee, it's the admissions, review, and dismissal committee, decides the child needs. Anything, okay? So if the kiddo needs it, it needs to be in the IEP, and we need to provide it. The stated purpose of the IDEA is to ensure that, quote, all children with disabilities have available to them a FAPE, that is a free, appropriate public education, designed to meet their unique needs and prepare them for further education, employment, and independent living. And that last part is really, really important because we're aiming toward helping that child have a life and have a future after school, not just get a diploma and, well, our work here is done. So we're really supposed to be designing programming to help the child have hope and a future. So this is something that sometimes people forget. Essentially, the purpose of the IEP is to tailor the education to the child, not tailor the child to the education. So we look at what does this student need, and we need to provide that, versus, well, here's what we have, so let's pick the least offensive thing for this child, okay? And so Texas actually has a codified mission that is even more generous in its language than the items that I just read to you. So Texas's codified mission is to ensure that all Texas children have access to a quality education that enables them to achieve their potential and fully participate now and in the future in the social, economic, and educational opportunities of our state and nation. So that's what we're supposed to be aiming for when we're writing these IEPs for kids. So once an IEP is written, we've taken all these things into account that we've just discussed, and the parties agree to it. Everybody says, yeah, you know, I think this is a good plan for the student. Then the parent signs a consent for eligibility for special ed and related services, and then also for the services themselves, and then the services begin. If, on the other hand, the parent does not consent to an offer of initial eligibility, so the first time the student is being made eligible for special ed, then the district cannot make the child eligible and cannot put in place the IEP that the district is offering. So that initial eligibility needs to be front-loaded for those services to begin. And here are some placement examples. We talked about placement a moment ago. General ed, we talked about special education classes. Sometimes those are resource classes. Resource classes are typically designed to give more individualized instruction in one or more areas where the student is struggling in particular. So let's say the student is performing pretty well in most areas, but just really, really, really struggles in reading or math. Then the student could be pulled out of the general ed classroom and put in a resource setting for that one class or two classes that really the student is struggling in, so that the student can be given some targeted instruction and basically be able to stay up with peers where they might not be able to if they were simply in the general education setting. Other examples, a life skills setting. The life skills settings typically are for students who are performing at a low cognitive ability level and need to have the work modified extensively from the general ed curriculum. And so day treatment can also be a placement. So for examples of that would be something like an applied behavior analysis ABA program for a student with autism who needs an ABA program. That is not something that's typically available in the general ed classroom. So the student may need intensive therapy. That's one example. Another is a student who goes to a specialized school, such as a school that caters to students with dyslexia or behaviors or something like that. Residential treatment center we talked about. The Texas Education Agency actually keeps a list of non-public service providers and placements that are approved by TEA. And those are day treatment facilities and also residential treatment facilities. That list exists to assist school districts and parents, as TEA will frequently help pay the local public school pay for those placements. They can be fairly pricey. So if it's on the approved list, that helps speed up the application process for funding assistance from TEA. Homebound placement. Sometimes students are actually placed at home to receive their educational services, and a teacher and therapist come to the family home and deliver services to the student there. Sometimes it can be because, say, there's a student who has a compromised immune system and can't be, you know, in the typical swimming pool of germs that you get in the public school. And so, you know, it may be a short-term type situation where the student needs, that sort of placement in order to, maintain their progress in school. Okay, and some of the hot topics in placement. So some of the special education hearings that end up in hearings as opposed to settling deal with issues such as private placement. So frequently those end up being the ones that are litigated, and the some of these placements can be very expensive. For instance, a residential treatment center can be $200,000, $300,000 a year. So school districts typically are not going to just readily agree to those because of the high cost. So those frequently get litigated. Sometimes they don't. I settle cases frequently where we're asking for residential placement and the school district agrees to do that, but that's not the typical thing that happens. Typically, we end up litigating those cases. Another I guess hot topic is general education settings for students with Down syndrome. A lot of parents of students with Down syndrome want their child in the general education classroom because they want the child to be exposed to typical peers. These are the individuals that the students are going to be dealing with in their future lives after school, and parents want those social skills to be learned, and the getting along with peer skills to be learned in the classroom. There's been some litigation on this issue. The case law has been more favorable to students staying in the classroom in other circuits than it has been here in this area. But that is definitely a hot topic, and it's something that parents are very concerned about, and they're willing to go to hearing over these issues. And then another thing that is frequently happening in schools is students with autism are being placed in behavior units at school districts, and that is nearly never a good idea. To place students with emotional disturbances with students with autism. It's a recipe for disaster, but it's happening frequently, and it's again because of what we have is what you get, rather than we're going to give individualized services based on what the student needs. So, and then go ahead to the next slide. Okay, so we're going to switch topics. So there is an anti-aversive law that is now official. This is good. So House Bill 3630 was signed by the governor, and it became effective in June of 2019. The author of the bill was Representative Morgan Meyer, and sponsor was Senator Eddie Lucio Jr. The bill prohibits the use of aversive techniques on special education students. These, what do we mean by this term? These are defined as techniques or interventions that are intended to address behavior by intentionally inflicting significant physical or emotional discomfort or pain on students. Yes, we actually have to tell people this and make a law about it. So to give you examples of what aversive techniques means, it includes a technique or intervention that is designed to cause physical pain, and that doesn't include allowed corporal punishment, so such as, I'm assuming, spanking, those sorts of things that if the parent says, okay, go ahead with the next, yeah, okay, that is likely to cause pain through the use of electric shock or any procedure that involves the use of pressure points or joint locks, or involves the release of a noxious toxic or otherwise unpleasant spray, mist, or substance near the student's face. These things actually have happened in the past. Or which denies adequate sleep, air, food, water, shelter, bedding, physical comfort, supervision, or access to a restroom. Or that ridicules or demeans the students in a manner that adversely affects the learning or mental health or constitutes verbal abuse. It also prohibits using a device or material or object that immobilizes all four extremities, including prone or supine floor restraint, impairs breathing, or restricts circulation. Restraint techniques require specific training. One of the techniques is CPI. School district staff who are in classrooms where restraints might be needed are supposed to be trained and certified in CPI techniques for purposes of, not injuring the person who they're trying to restrain. Requires the student to a station, secures the student to a stationary object while sitting or standing. So not tying people up. Inhibits, reduces, or hinders the student's ability to communicate. No tape over the mouth. Yeah, that's actually happened as well. Involves chemical restraint. I don't know what that would be. Giving medication? I'm not sure. Constitutes a use of timeout that precludes the student from progressing appropriately in the curriculum and annual goals in the IEP, including physically isolating the student. Deprives the student of one or more senses, except this can be done if it does not cause the student pain or discomfort and complies with the student's IEP or BIP. So if there are things that are needed for the student and they're actually contained in the student's IEP and agreed upon by the school district and the parent, then those things can be used. So the IEP can write in exceptions to any of the laws, if everybody agrees to it and signs off on it. And a school district employee, volunteer, or independent contractor cannot use, order, or consent to or cause an aversive technique to be used on a student. So this is intended to cover, people who come in from, the outside, such as, third-party services providers, the local parent who's serving as a volunteer in the classroom, that sort of thing. So just to make sure that it covers not only employees, but also these other individuals who might come in to the public school. And it clarifies, just, to make sure that everybody knows that the law does not prohibit a teacher from removing a student from class under the current disciplinary law. So, for example, a student shows up to school with a weapon, a deadly weapon, or drugs, or is about to inflict serious bodily injury on someone. Those are situations where they wanted to make clear they can still go ahead and comply with the other laws that currently exist. There are state and federal laws related to removal of students from the classroom. So the Commissioner of Education is supposed to provide guidance to the employees, volunteers, and contractors on how to avoid a violation of this law. And I haven't looked at the TEA website recently. I'm hoping that they've, posted some guidance to help everybody sort of understand what the expectations are and how they can readily comply with the law. I'm hoping that comes out before the start of the school year. But, you know, they haven't had that much time to put this together. You know, the law went into effect in June. So, you know, hopefully it'll be before the beginning of the school year. Okay, so I'm going to open this up for questions. If anybody has questions, I'm happy to answer them. On the other hand, if you want to hold your question and email me, my email information will be posted here shortly as well. And I'm happy to answer, you know, answer questions on email if you think of something or you don't want to ask it, you know, in a group setting. So.
Okay, well, I have a couple already.
Okay.
So this is back at the beginning. When did the information,
okay.
or where did the information for the 60-day timeline for reevaluations come from? The scope and timeline of a reevaluation is determined by the ARD committee. The requirement is that it must be completed by the 3-year evaluation due date.
I don't disagree with that. Yeah, so if everybody signs a consent form, then it needs to be done within 60 days. So that would come into play if it's before the 3-year reevaluation timeline. And I would agree with you that it must be done by the 3-year timeline. So in other words, if we sign a consent, if we sign a consent for evaluation form, and it's, you know, a year out or 2 years out from the prior evaluation, then the 60-day timeline would hold. But if it's coming up on the 3-year re-eval timeline, then it must be done by that deadline as well. So yeah, that's a good clarification question. Thank you.
All right. And does the 60 days include holding the ARD as well?
I believe that there is a timeline. It must be done within, I believe it's 30 days after the evaluation is completed. That's the best of my recollection, but you know, it's in the TEA commissioner's rules if you want to look up that timeline and verify that I'm right.
Okay, this is more later in the session. Does in-school suspension fall under the aversive techniques?
No, I mean, the schools do have legitimate reasons to do in-school suspensions and even out-of-school suspensions. And as long as they comply with those laws, I mean, I don't believe the aversive law was intended to address really any of those things, because those already are pretty well covered with, you know, their own separate laws. So yeah, I think it's just to distinguish that it's not intended to walk over or step over those other laws, but those other laws are still good laws.
Are the 45 and 60-day timeline restrictions, are those school days or calendar days?
I believe that those are school days, and there's also some strange timelines in the commissioner's rules that if it's done within so many days before the end of the school year, then you know, the timeline stops and then it resumes at the beginning of the next school year. So, you know, I haven't had to do those calculations for a while. But yeah, there's all kinds of weird calculations that come into effect. And to be honest with you, I don't have them memorized. I have to look them up every time that becomes a question in a case. Okay, now let's refresh our memory on these timelines because they're bizarre, actually, in my opinion.
My understanding is if the date of evaluation due is indicated on the consent form, signatures can be obtained more than 60 days out. Is that correct?
Okay, say that again.
My understanding is if the date of evaluation due is indicated on the consent form, signatures can be obtained more than 60 days out.
Yeah, I mean, the parties can agree to anything they want. So yeah, I mean, if you all agreed that there was some need to have the evaluation process take longer or more days, as long as that's agreed to, it's fine. Yeah. I wouldn't raise that as an issue in hearing if, you know, if the parties agreed to something and it was outside the 60 days, but it was an agreed upon thing, I wouldn't complain about that in the hearing because that's something everybody agreed to, and that was the, you know, the playbook that everybody was planning to use. So, yeah.
Can a REED done in place of the 3-year re-eval? I don't know what.
Yeah, frequently that ends up happening.
Can you explain what that is?
Sometimes
not everyone may know.
Okay, a read. A read is a review of existing evaluation data. And so, for instance, a read might be appropriate in a situation where, you know, let's say, for example, the student's IQ has been stable for a number of years. There's been a lot of prior evaluations. There's really not necessarily a need to do new IQ testing on the student. So in that instance, you could do a review of existing evaluation data and, you know, just go with that. Sometimes I've seen reads done where the school district wasn't paying attention to deadlines and didn't have time to do the evaluation in a timely manner. By the time they realized, oops, you know, the 3-year re-eval is due. So without basically disclosing that to the parent, they suggested in the ARD meeting, oh, let's just do a read instead of, you know, testing Johnny again. And, you know, I've seen cases where that was actually discussed in email chatter and that sort of thing. But, you know, sometimes it's a staffing issue. You know, there are too many kids who need evaluations and not enough staff members to do it. So we're just going to do this the easy way. I recommend against reads, generally speaking, although they're appropriate in some instances, because we want that information in order to build appropriate goals and objectives. In order to do that, we need to know what the present levels of performance are on the various skills. So, you know, how is Johnny doing with this or that skill? We're going to find that out in the evaluation process. So I generally recommend against reads, you know, because that's data that you really need in order to build an appropriate IEP.
Okay. What brought on the need to pass this adverse techniques law? Can you share some information about how that all came about?
I wasn't necessarily involved with the, you know, bringing, you know, lobbying for this law and this sort of thing. I really just have more of a general awareness. Sometimes I am contacted by parents who have had, you know, really awful things happen to their kids at school in terms of isolation. For instance, you know, the child has dangerous behaviors, and rather than addressing those behaviors, the school district is, you know, locking the kid in a room by himself. And, you know, he's spending, you know, most or all of his day, you know, in basically an isolation room rather than, you know, with other kids. That's a concern that I have seen, you know, or that parents have brought to me frequently. Other things, you know, over the years, you know, kids get duct taped to chairs. Kids, you know, have their mouths duct taped. Kids having stuff sprayed in their face, you know, when they, you know, do something that, you know, the teacher or the aide is upset about. You know, I don't know if it's an attempt to redirect the student or what, but, you know, if you can think of it, it's been done to a special ed student at some point. There was a need felt that, you know, we need to actually have legislation so that, you know, we can point to a law that says, no, you can't do this. This is not a behavioral intervention. This is not a positive behavior support. This, you know, borders on or is abusive. So, yeah, sometimes we have to make laws on stuff that seem like common sense. And, you know, and I think most good teachers and staff members would not do most of these things that the law prohibits. They didn't go into teaching because they wanted to torture kids. They want to help them. And so, you know, this is written for, you know, the people who, you know, don't have their heart in the right place.
Gotcha. I remember when I worked with the deaf community that some of the related services also could be for parents, like say if the student was using sign language or was going to be using sign language, then the school could provide, so that the child had communication at home as well, could provide sign language classes or pay for sign language classes for the parent. Can you talk a little bit about some of those kind of options for parents?
Yes, that is a very good question. So there are related services that are also related to training the parents to work with the student. So let's say, we're going to be teaching American Sign Language to the students at school. There's going to be goals and objectives. There's going to be somebody certified. There's going to be interpreters. There's going to be there's going to be this program for sign language. And if you have a parent who is not deaf, and who, does not know sign language, in order for that student's sign language education to be beneficial in the home setting, the student needs to be able to communicate with the parent and the parent with the student. So that could potentially include doing sign language training for the parent or the student's siblings. It could be sending parents to conferences for them to learn behavioral techniques, all sorts of other things. So there's parent training, there's in-home training. Frequently that is seen as something that goes with students who have autism spectrum disorder, but it can be used, for parents of any student, really. There's parent counseling. So, if the parent needs counseling to help the parent cope with or better address things with the student and serve as a better parent for the student, those things can also be offered. Those things actually can be put in the IEP. Parents can be sent to conferences such as I frequently ask for parents to go to learn more about their rights at like Disability Rights Texas conferences or COPA conferences. That's a Council of Parents, Attorneys, and Advocates. And there are many other, the regional service centers frequently put on parent trainings as well. And those are usually free. So, you might want to check out your regional service center and see if there's something that, is going to be helpful to you in that regard.
Okay. Placement. Sometimes people think of placement as what program is going to be involved, but sometimes it's a physical location placement as well. Can you talk a little bit about how the physical location is decided?
Well, placement is not simply the location of the services, okay? I mean, the definition under the law is it includes the program and services as well. So it's not just the classroom. So for instance, in the past, I haven't heard it so much recently, but in the past I've heard, we're going to put Johnny in the LRE room. Well, least restrictive environment is not a room or a place. It's what's appropriate for the student. So by calling a room LRE, that means the person doesn't necessarily understand what LRE, least restrictive environment, actually means. So it's basically when courts look at what is placement, they're looking at the whole picture. What is the child's program? What is he receiving? What are the student to teacher ratios? What's the classroom setting like? I mean, so it's really the collective program, not necessarily just, the specific classroom, room 108. So, yeah.
And sometimes it could be at a different campus.
Yes. And sometimes school districts will be involved in co-ops, or they will put special programs for low incidence disabilities on one particular campus. So let's say, for example, the school district has maybe 4 or 5 kids who are deaf and who everybody believes needs to be in basically a sign language classroom. So everybody in the classroom knows sign and is able to communicate. What the school district might do is put all of those kids in one classroom at a consolidated campus to deliver those services, rather than have one kid by himself in a class another kid in a different class in a different school, that sort of thing. So school districts will frequently pool resources so that they can, you know, give the kid an appropriate program, you know, when there aren't a lot of kids who have that particular issue. You know, unlike something with dyslexia where there's going to be a lot of kids who have that issue, you know, that sometimes is a good way to use the resources and really benefit the child more than he would get otherwise.
All righty. Clarifying question. If those services, when we were talking about related services for parents, are placed in the IEP, is the district legally required to provide and pay in some cases for these services?
Yes, ma'am, they are. And if it's in the IEP and it's not being done, that is a violation of the law. And so the quick remedy for that is not to call me, but you can file a TEA complaint. Texas Education Agency has on its website complaint forms. You can fill it out. Say my school district put in my child's IEP that they were going to do X, Y, and Z. They're not doing X, Y, and Z. Please make them do X, Y, and Z. And then TEA will assign a complaint investigator and, you know, get in touch with the school and find out, you know, is the school not giving those services that it agreed to give? And so TEA has the ability to kind of put some pressure on the school district to get those things done. So if it's something that is like how much services the student should get, that's not really appropriate for a TEA complaint. It's more for procedural issues, such as the school was supposed to do this and they didn't, to make them do it. So you don't need a lawyer to file a complaint about non-compliance with the IEP. You could just do that on your own.
Very good. All right, well, I'm going to ask if there's any last minute questions because that's all we have so far. I made a note about consent, but now I can't remember what I was going to ask you. So.
Okay.
And you shared where you got that 15.4%. That was a hyperlink in the materials, correct?
Yes, ma'am.
Okay, so just everyone know that when we send these materials after the session, the things that you see in green, all of those are hyperlinks to that, well, email addresses or websites that you can actually look at the information that Dorene has shared with us.
Okay.
Well, I see no more questions, so I want to thank you for attending the session today. I'd like to give a special thank you to Dorene Philpot for giving us her time today and Texas Closed Captioning for the real-time captioning services. I hope you have a great rest of the day and a great weekend. Thank you so much, Dorene.
Thank you so much. Have a great weekend. All right. Bye-bye.